Imagine this. You've been injured, or you're dealing with a serious illness and your doctor says you need time off. You do the right thing, you notify your employer and take approved medical leave. But then a new worry hits you. Can I be fired while I'm out? It's one of the most common questions American workers ask, and the answer isn't simple. The truth is, being on medical leave gives you legal protections, but it doesn't make you untouchable. Depending on the circumstances, your job may be safe, or your employer may still have grounds to let you go. In this video, I'll break down the laws that apply, like the Family and Medical Leave Act, FMLA, the Americans with Disabilities Act, ADA, and state workers' compensation rules, so you'll know exactly when a firing is legal and when it crosses the line into wrongful termination. Part 1. The basics. At-will employment and medical leave. Protections. To answer whether you can be fired while on medical leave, we first have to look at two overlapping principles: at-will employment and federal leave protections. In the U.S., most workers are employed at will. That means your employer can fire you at any time, for almost any reason, or no reason at all, so long as it's not an illegal reason. At-will employment is the default in nearly every state. Now, here's the critical point. Medical leave laws create exceptions to that rule. Under federal law, two big protections come into play: the Family and Medical Leave Act, FMLA, and the Americans with Disabilities Act, AADA. The FMLA gives eligible employees up to 12 weeks of unpaid, job-protected leave in a 12-month period for serious health conditions, caring for a family member, or welcoming a new child. If you qualify and your employer is covered, they cannot fire you simply for taking FMLA leave. When you return, you're entitled to your same job, or an equivalent one with the same pay and benefits. The ADA works differently. It doesn't guarantee a set amount of leave, but it requires employers to provide reasonable accommodations to employees with disabilities. In some cases, that includes time off for treatment or recovery. If additional unpaid leave is a reasonable accommodation, firing you instead of granting it could violate the ADA. That said, protections aren't unlimited. The FMLA only applies if your employer has 50 or more employees within 75 miles, and you must have worked there at least 12 months and logged at least 1,250 hours in the past year. If you don't meet those criteria, you may not be covered. Similarly, the ADA only applies to employers with 15 or more employees, and it doesn't protect workers if the leave requested creates undue hardship for the business. So, while at-will employment gives bosses broad power, laws like the FMLA and ADA carve out exceptions. If you qualify, your job is protected while you're on medical leave. If you don't, or if your employer can show a legitimate, non-discriminatory reason for firing you, the situation becomes more complex. Part 2. FMLA, Job Protection and its Limits. The Family and Medical Leave Act, FMLA, is the main federal law most workers think of when they ask about medical leave. It provides up to 12 weeks of unpaid, job-protected leave in a 12-month period for eligible employees. But understanding exactly what that means and its limits is critical. First, let's talk about eligibility. You only qualify if you've worked for your employer for at least 12 months and logged at least 1,250 hours in the past year. Your employer must also have 50 or more employees within 75 miles. This means many small businesses aren't covered, and not all workers are eligible. If you do qualify, FMLA guarantees two big rights. 1. Job protection. When your leave ends, you must be restored to your original job or to an equivalent position with the same pay, benefits, and working conditions. 2. Continuation of health benefits. While you're out, your employer must maintain your group health insurance as if you were still working. But here's the part workers sometimes miss. FMLA is not absolute job security. You can still be lawfully fired while on FMLA leave if the reason is unrelated to your medical leave. For example, if your company is undergoing layoffs and your position would have been eliminated even if you were at work, your employer can include you in that layoff. Or if they discover serious misconduct, say falsifying records, while you're on leave, they can terminate you for that reason. What they cannot do is use your leave itself as the reason. Another limitation is the 12-week cap. Once you've used up your 12 weeks, your employer is not obligated under FMLA to hold your job any longer. Some workers mistakenly think they can take unlimited time off, but once the protected period ends, at-will employment rules kick back in. There are also special rules for military caregiver leave, which extends up to 26 weeks. But for most workers, the 12-week limit applies. One more nuance: employers sometimes make mistakes by retaliating against workers for even requesting FMLA leave. The law makes it illegal to fire, demote, or otherwise punish you for exercising your right to request or take FMLA. So if you're targeted because you asked for leave, that may be wrongful termination. In short, FMLA is powerful. It guarantees job restoration and protects health insurance. But it's not a shield against every possible termination. You can still be fired if the employer has a legitimate, non-leave related reason. Part 3. The ADA, leave as a reasonable accommodation. While the FMLA sets a clear 12-week standard, the Americans with Disabilities Act, ADA, offers another layer of protection for workers whose health issues qualify as disabilities. Under the ADA, employers with 15 or more employees must provide reasonable accommodations to qualified individuals with disabilities, unless doing so would cause an undue hardship to the business. So what does that mean in practice? Time off can be considered a form of reasonable accommodation. For example, if an employee with cancer needs additional weeks of recovery time after exhausting FMLA leave, the employer may be required to grant more unpaid leave, so long as it doesn't create a severe burden on the company. Courts have repeatedly recognized extended medical leave as a valid accommodation under the ADA. But there are limits. The ADA does not require employers to grant indefinite leave. If an employee can't provide an estimate of when they will return to work, courts have generally found that employers are not obligated to hold the position open forever. Similarly, if granting extra leave would cause significant disruption, say, a small business losing its only accountant for months, an employer may argue that the request poses an undue hardship. Importantly, the ADA also requires an interactive process. That means the employer and employee must communicate in good faith about possible accommodations. If you need more time off, your employer can't just shut the door. They're supposed to discuss whether extended leave, a modified schedule, or even part-time return to work options could help. Another key protection under the ADA is against discrimination. An employer cannot fire you simply because you have a disability or because you requested a reasonable accommodation like medical leave. If you're terminated for that reason, it's wrongful termination. Here's a real-world example. A warehouse worker injures his back and uses up his 12 weeks of FMLA. His doctor says he'll be cleared in 4 more weeks. The employer refuses and fires him immediately. That could violate the ADA because a short extension of leave may be considered reasonable, especially for a large company that can cover the workload. So, while the FMLA gives a fixed amount of job-protected leave, the ADA provides a flexible framework. If your medical condition qualifies as a disability, you may be entitled to additional leave or other accommodations, and firing you instead of exploring those options could be unlawful. Part 4. Workers' compensation, state laws, and when termination is still legal. Medical leave doesn't only come from the FMLA or ADA. Many employees take time off because of a workplace injury, and that usually involves workers' compensation laws. These state-level systems provide medical treatment and wage replacement if you're hurt on the job. Here's the key. Most states make it illegal to fire an employee simply for filing a workers' comp claim. That would be retaliation, and courts treat it as wrongful termination. If you're injured at work, report it, and then suddenly lose your job, you may have a strong claim. But just like FMLA and ADA, workers' comp laws don't give unlimited job security. If you cannot return to work after a reasonable recovery period, or if your injury makes it impossible to perform essential job functions even with accommodation, your employer may eventually terminate your employment. The law requires fair treatment, not permanent job guarantees. Beyond workers' comp, state family and medical leave laws also come into play. States like California, New York, Massachusetts, New Jersey, and Washington go further than the federal FMLA by offering paid family or medical leave programs. These laws typically provide wage replacement during leave, and some include stronger job protections than federal law. For example, California's Family Rights Act, CFRA, mirrors FMLA, but applies to smaller employers and sometimes extends protections beyond the 12-week federal cap. Now, let's talk about when termination is legal during medical leave. Employers are allowed to fire employees who would have lost their jobs regardless of being on leave. For instance, if your company shuts down your department or goes out of business, your leave doesn't protect you from being laid off. If you were already under investigation for misconduct before you took leave, and the company decides to terminate you for that reason, it's legal. If you can't return to work after exhausting all leave rights under FMLA, ADA, or state laws, the employer may lawfully end your employment. Employers, however, must be very careful. They need solid documentation proving the termination is unrelated to the leave itself. If the timing looks suspicious, like being fired right after requesting leave, courts often presume retaliation unless the employer shows a legitimate reason. The bottom line, workers' comp, ADA, FMLA, and state laws all create protections, but none are absolute shields. Medical leave means you have strong rights, but it doesn't guarantee you'll never be terminated. The difference lies in why you were fired. Part 5. How workers can protect themselves and real-life examples. If you're worried about being fired during medical leave, the best defense is knowing your rights and keeping strong records. Employers sometimes try to justify a termination with vague reasons like performance or restructuring. Having evidence can make all the difference if you need to challenge it. Start by documenting everything. Keep copies of your leave request forms, doctor's notes, emails with HR, and any written approvals. Note the dates you requested leave and when it was granted. If your supervisor makes negative comments about your absence, write those down too. These records can help show whether the termination was really about your medical leave. Second, monitor the timing. Courts often look at how close in time your termination was to your leave request. If you were fired right after asking for FMLA or filing a workers' comp claim, that timing itself raises red flags. Third, know where to file complaints. For FMLA or ADA violations, you can file with the U.S. Department of Labor or the Equal Employment Opportunity Commission, EEOC. For workers' compensation retaliation, you typically go through your state's labor board or workers' comp agency. These agencies investigate and can order back pay, reinstatement, or damages. Fourth, consider legal advice. Employment attorneys often take wrongful termination or retaliation cases on a contingency basis, meaning you don't pay unless you win. They can help you navigate strict deadlines like filing with the ECC within 180 days and build a strong claim. Here's a real-world example. A hospital nurse in Illinois took FMLA leave for surgery. While she was recovering, the hospital claimed they needed to fill her role and terminated her. She sued, and the court ruled in her favor, finding that FMLA guarantees job restoration. She received back pay and damages. Another case involved a construction worker injured on the job who filed for workers' comp. A week later, he was fired for attendance issues. The court ruled the firing was retaliatory because the absence was directly tied to his injury. The employer was ordered to reinstate him and pay lost wages. The lesson is clear. If you're fired while on medical leave, don't assume you're powerless. With documentation, complaints, and sometimes legal action, you can fight back, and many workers do win. So, can you be fired while on medical leave? The answer is, it depends on why. Laws like the FMLA, ADA, workers' compensation rules, and state leave programs give strong protections. They make it illegal to terminate someone simply for taking approved medical leave or for requesting accommodations. But those protections aren't unlimited. Employers can still fire workers for legitimate, unrelated reasons, like layoffs, misconduct, or if the leave extends beyond what the law requires. The key is whether your termination was truly about your medical leave or just disguised as something else. That's why documentation, timing, and legal guidance matter so much. If this video helped clear things up, hit like, share it with a coworker, and subscribe for more plain English explanations of workplace law. And tell me in the comments, have you or someone you know ever faced job loss while on medical leave?